Good afternoon. We welcome all the members to today's webinar on recent judicial pronouncements under IBC, organized by Committee on Insolvency and Bankruptcy Code of ICAI. The speaker for the webinar is Advocate Aditya Srinivasan, and the webinar is going to be moderated by CA Atul Kansal. We welcome both of you, sirs. I would take this opportunity to introduce our speaker as well as moderator for today's webinar. Aditya Srinivasan is an advocate based out of Delhi. He is graduate with a BA LLB honors. He frequently appears in the Supreme Court of India, the Delhi High Court, the National Company Law Tribunal, Appellate Tribunal, and the Income Tax Appellate Tribunal. He began his career as a taxation and investment funds lawyer. He spent more than 3 years where he worked with the corporate law practice groups of internationally reputed law firms. His litigation practice comprises various disputes relating to arbitration, insolvency, taxation, commercial laws, securities regulation. Now, I would like to introduce CA Atul Kumar Kansal. He's a fellow member of ICI, having experience in corporate finance and accounts, working capital management, financial planning and analysis, internal control system implementation and audits and commercial functions in diversified industry segments. He's a registered insolvency professional, having vast experience as a resolution professional and liquidator. He is currently handling several assignments directly or indirectly as RP or process advisor. He's also part of faculty of pre-registration educational training and has delivered several lectures covering the topic of insolvency and liquidation. With this, now I would request CA Atul Kansalji to start with your initial remarks. Then I would request you to hand over the session to Aditya Srinivasan. Over to you, Atulji.
Thank you, Rita ma'am. Thank you. Myself Atul Kansal. So, friends, the objective of today's webinar is the law is evolving. There has been 6 years of IBC, but still law is evolving. So many disputes are coming for the claims, like whether claims should be accepted after 90 days, whether claims should be accepted after the submission of judicial plan to the COC or submission of judicial plan to the NCLT for approval. So all these kind of things are evolving now. Recently, there was a judgment from the Supreme Court in which they have clarified whether the claim can be accepted after the approval of plan by the COC or not. So I will not take much time, and in the last of the session, we will take up the question answer session. So I am handing over to the charge to Aditya Srinivasan ji. So Aditya ji.
Thank you so much, Atulji, and thank you, Rita ma'am, for a very kind introduction. So as Atul and Rita ma'am have already said, this session is going to be on recent judicial pronouncements under the IBC. What I've done is I've prepared a presentation that looks at 6 Supreme Court judgments of 2023 and 2 related Supreme Court judgments of 2022. So that's 8 judgments. I know the time is very limited, but I'll do my best to go through all of these judgments.
It is going to be a very helpful and knowledgeable session, right?
So I'm just going to share my screen and put up the presentation. Atulji, if you can just confirm screen can be seen, correct?
Yes, we can see the screen.
Yes, we can see.
Thank you. So these are the various topics on which I'm looking at some judgments. I think Rita ma'am has already given a very kind introduction, so I won't repeat any of this. So these are the 8 judgments that we're looking at. Right. The first on the list is Sabarmati Gas Limited versus Shah Alloys Limited. The issue over here in this judgment might seem to be a very simple and straightforward issue, but the reason I want to talk about this judgment is because even though, as Atulji mentioned, it's been 6-7 years since the IBC has come into force, we continue to see issues with respect to some of these things like limitation period, how it should be computed, what should be excluded, etc. In this particular case, there was the facts were such that the corporate debtor was initially taken before the BIFR, the Board for Industrial Reconstruction, Financial Reconstruction, I'm sorry, for a period of time, and thereafter the IBC came into force, and the proceedings before the BIFR were abated. Then when the operational creditor wanted to initiate a Section 9 proceeding to take the corporate debtor into insolvency, one of the oppositions or objections that were made was that, look, the period of limitation has expired as far as the corporate debtor is concerned, because a default took place well before the Section 9 petition was filed. So we look at this judgment as well. This was one of the first judgments under the IBC that was pronounced in this year. So as you can see, it came out on the 4th of January 2023. And the judge who wrote the judgment was Justice C.T. Ravikumar of the Supreme Court. So I've just culled out in each of these judgments, I've just culled out what I consider to be the material facts, just for the purposes of aiding an analysis and a discussion of this. So as you can see, there was a gas sales agreement of 30th May 2008, whereby Sabarmati Gas Limited agreed to provide natural gas to Shah Alloys Limited. At some point in 2011, there was a default on the payments by SAL. SAL is Shah Alloys Limited. And in the meanwhile, SAL had already approached the Board for Industrial and Financial Reconstruction to get itself declared as a SIC company and to get a plan for rehabilitation. That declaration was made by BIFR on the 31st of August 2010. And the same way we have a Section 14 under the IBC, there was I would not say an exactly same provision, but there was an equivalent provision, you could say, under Section 22 of SICA, pursuant to which a moratorium came into effect. And this moratorium effectively precluded SGL, that is Sabarmati Gas Limited, from recovering its outstanding dues. So the matter was being pursued in the BIFR, and meanwhile, in August 2012, SGL stopped the supply of gas to Shah Alloys Limited. Then in March 2013, since the matter was going on in the BIFR, SGL approached BIFR to seek permission to initiate proceedings to recover its outstanding dues. It was approximately 4.7 crores. And the way this particular application was disposed of was that a direction was issued that SGL's dues should also be incorporated in the DRS, the Draft Rehabilitation Scheme. All right. So this is where sort of proceedings at BIFR come to a close. On the 1st of December 2016, SICA was repealed, BIFR became functus officio, and various provisions of the IBC came into effect. In April 2017, SGL issued a demand notice under Section 8 to Shah Alloys Limited. On the 10th of April, Shah Alloys Limited replied to this notice. Essentially, they took two grounds. One, they said that, look, you're way past the limitation period as far as the Limitation Act is concerned. And secondly, it also highlighted that there appeared to be some pre-existing disputes between the parties. In any event, SGL then moved a Section 9 application before the NCLT. This came to be dismissed in June 2019. As I mentioned to you, the two grounds on which it was dismissed were, one, limitation, and two, the presence of pre-existing disputes. Aggrieved by this decision of the NCLT, Sabarmati Gas Limited appealed to the NCLAT, where also the matter came to be dismissed. And so then it came to the Supreme Court. All right. So there were, just on these facts, I think it becomes clear that there were two broad issues involved over here. I'm only going to discuss one of them. The two broad issues were, one, is the Section 9 petition that was filed by Sabarmati Gas Limited within the limitation period? And the second issue that was discussed was, are there any pre-existing disputes? And if so, does that defeat the Section 9 petition? I'll come to both conclusions. I'm only going to discuss the first issue just for the benefit of our listeners and viewers. So these were the broad contentions that were taken by the parties. Right? SGL said that by virtue of Section 22, subsection 5. So you'll recall I mentioned that Section 22 was kind of an equivalent moratorium provision under SICA. So by virtue of Section 22, subsection 5, the period of suspension under SICA between 31st August 2010 to 1st December 2016 need to be excluded while calculating the period of limitation. While calculating the period of limitation for the purpose of determining whether the Section 9 petition was filed within time or not, right? So SGL obviously says that, look, this period during which the company was in before the BIFA, that needs to be excluded when you calculate the limitation period. In response, Shah Alloy Limited says that you need to consider this Section 22 in a very limited sense. If you carefully review the language of Section 22, subsection 1, the prohibition was only with respect to executing the awards or the decrees that were granted by various forums. It was not on actually pursuing the recovery proceeding, and so you could have pursued the recovery proceeding, but you could not have enforced it. That was the basic contention that Shah Alloys Limited had taken. So now we come to the judgment, and I think on both of the issues, the Supreme Court was fairly clear. But as far as the first issue is concerned, it says that, look, the intention appears to be to protect the interest of a party who was prevented from lawfully enforcing the right to seek recovery of dues during the operative period under Section 22, subsection 1. Any other understanding of the provisions under Section 22, subsection 5 would be wholly pointless and purposeless, right? Because if you were to construe it in any other way, then it would essentially lead to the rights of the parties being defeated, not just under SICA, but even under the IBC. That's the point that they were trying to drive home. And it goes on to say that, when the appellant, being a party to BIFA, in the sense on intervention, it obtained an order to have its dues incorporated into the DRS, whether there would be any justification to hold that on repeal of SICA, it could not claim the benefit flowing from the provisions under Section 22, subsection 5. And the judgment then goes on to confirm that essentially, as it applies to a Section 9 application under the IBC, the period when the company was in BIFA needs to be excluded for the purposes of calculating the limitation period, for the purposes of Article 137 of the Limitation Act. And this is where the judgment gets a little bit interesting. It rules on this first issue in favor of the operational creditor. The operational creditor is Sabarmati Gas Limited. So it says that, look, that period when the company was before the BIFA, that needs to be excluded. But it then comes to the second issue, and it identifies that there are very credible pre-existing disputes between the parties. And so, although we agree with the operational creditor as far as the first issue is concerned, because of the fact that there are pre-existing disputes, we need to ultimately end up dismissing the appeal. So you can see the conclusion over here. The appeal was ultimately dismissed on the point of the fact that pre-existing disputes were there, and thus the rigors of Section 9 of the IBC were not met. Okay, so with that, we come to the conclusion of the first judgment. You can please note down any questions, and you can let the moderators have them. A moderator have it, and then we can discuss at the end of the session. This is the second case, Shrey Multiple Asset Investment Trust Vision India Fund versus Deccan Chronicle Marketeers and others. This was a judgment that was delivered on the 17th of March 2023 by a bench comprising Justice Ajay Rastogi and Justice Bella Trivedi, and the judgment was delivered by Justice Ajay Rastogi. So in this case, the corporate debtor was Deccan Chronicle Holdings Limited. It was taken into CIRP. During the process of CIRP, a resolution applicant, which is Shrey, I won't necessarily go through the full form of the resolution applicant's name, but Shrey had submitted a resolution plan. This plan was approved by more than 80%, in fact, 81.39% of the voting share of the COC in December 2018. So then the resolution plan was presented before the adjudicating authority, and this plan was conditionally approved by the NCLT in June 2019. I say conditionally approved because there was an application that was pending in the NCLT. This is the NCLT Telangana, if I recall correctly. And the application that was pending in the NCLT Telangana was about the ownership of the trademark. So Deccan Chronicle, most of you will be aware that this was a very famous newspaper, which is very predominant in the South, but I think had circulation elsewhere as well. So it had trademarks for all of the newspapers, whether it was Deccan Chronicle or Andhra Bhumi. These were the two most famous ones. There were other trademarks as well. Now, ultimately, the NCLT passed a declaration that these trademarks belonged to the corporate debtor, and when the matter came up in the NCLAT took the view that this declaration that has been made by the NCLT regarding the ownership rights over the trademarks tantamounted to a modification of the resolution plan, and thus it set aside the NCLT's order. So we'll just go through some of these facts a little more carefully so that we can understand them. So I have reproduced over here on the screen clause 4.3 of the resolution plan itself. And you can just see the language of the resolution plan. It says it is of utmost importance that all 6 brands as aforestated can be used freely by the corporate debtor without any hindrance. In order to achieve the same, the above financial creditors shall be deemed to have released their right under the relevant security documents with respect to the said brands in favor of the resolution applicant. So these trademarks which existed of the company, all of these, I believe, security interests were created in respect of those trademarks, and those security interests were held by some of the financial creditors. So the resolution plan is saying that those financial creditors are deemed to have released their rights. And now let's just look at clause 11.12 of the resolution plan. Clause 11.12 of the resolution plan says that the corporate debtor, so this is the prayer that is being sought for in the resolution plan. It is requesting the adjudicating authority to pass orders to give effect to the fact that the corporate debtor has perpetual exclusive right to use the brands, namely Deccan Chronicle, Andhra Bhumi, and the other ones, including Asian Age. So one fine distinction to be noted over here. If you look at clause 11.12, you can see that the request is for the adjudicating authority to grant a perpetual exclusive right to use the brands, to use these trademarks. Whereas if you recall from the decision of the NCLT, a declaration was passed that the trademarks belonged to the corporate debtor. In other words, that they were owned by the corporate debtor, and this became the subject of the dispute between the parties. So we look at the contentions that were placed before the court. Right, so the appellant, which is Shrey, it went through the minutes of the COC to explain that what was being decided by the NCLT is nothing but approving the resolution plan. It does not amount to an alteration or modification of clause 11.12. And the NCLAT, which had taken the view that this amounts to a modification, has essentially committed a grave error, and that needs to be interfered with by the Supreme Court. In response, what the respondents said is that the resolution plan with reference to the right to trademarks was only confined to the perpetual exclusive right to use the trademarks. right? There was nothing in the resolution plan with respect to the ownership of the trademarks. And so to the extent that the NCLT has conferred ownership rights in respect of the trademarks, it has altered or modified the resolution plan, which is something which is impermissible in law on account of various judgments. So now we come to the judgment itself. So the bench says that if we look into the resolution plan and particularly clause 11.12, it is confined to the perpetual exclusive right to use the brands Deccan Chronicle, Andhra Bhumi, etc. by the corporate debtor. And since the resolution plan was made subject to the result of the pending IA number 155 of 2018, this is the IA in which the NCLT ultimately declared ownership rights of these trademarks to belong to the corporate debtor. So because it was made subject to that IA, the adjudicating authority had approved so far as the exclusive rights of the corporate debtor to use the trademarks under its order dated 14/8/2019. And this is the important part. But at the same time, a further declaration was made in para 30A, holding that trademarks Deccan Chronicle and Andhra Bhumi belong to the corporate debtor, which indeed does not reconcile with the resolution plan approved by the COC and later by the adjudicating authority. It says that the COC and the adjudicating authority have approved the perpetual exclusive right to use the trademarks, but they have said nothing about the ownership rights in respect of those trademarks. So till the time that the IA that was decided by the NCLT was confined to the right to use the trademarks, that everything was consistent with the resolution plan. The moment they went into making a declaration as to the ownership rights of the two trademarks, there the Supreme Court has said that, look, this does not reconcile with the resolution plan and therefore impermissible under law. Let's see further. It has not been disputed by the learned counsel for the appellant that once the resolution plan stands approved, no alterations or modifications are permissible. So we saw that. It clearly indicates that what was approved by the COC with 81.39% of its voting is to the effect that the corporate debtor has a perpetual exclusive right to use the brand. So we've seen all of this. And then it reiterates again over here, but the adjudicating authority, while adjudicating application IA number 155 of 2018, apart from upholding the exclusive right to use the trademarks Deccan Chronicle and Andhra Bhumi, made a further declaration that trademarks belong to the corporate debtor DHCL, which indisputably is impermissible in law. And this is what the NCLAT has essentially observed. So the appeal again over here was dismissed, and the judgment of the NCLAT was upheld. Right, that brings us to the end of the second judgment. Please do share your questions with the moderator and the team. And we can start with the third case. The third case is Victory Ironworks Limited versus Jitendra Lohia and another. And the question in this case was whether development rights in respect of a piece of land would constitute an asset for the purposes of Section 18, Clause F and Section 25, Subsection 2, Clause A. This judgment came out on the 14th of March 2023. It was authored by Justice V. Ramasubramaniam, who is a fantastic judge. I mean, I really do enjoy reading judgments that have been authored by him. And this particular judgment is no exception. Okay, so some background. First, UCO Bank was selling a parcel of land under the Sarfasi Act. There was a company called Energy Properties, which was looking to buy that piece of land, and it entered into an agreement with the corporate debtor to purchase that piece of land. Now, as per the terms of the agreement that was entered into between Energy Properties and the corporate debtor was to provide financial assistance of 2.7 crore to Energy Properties to purchase the land. And in addition to this, the corporate debtor also agreed to provide an amount of 9.3 crores to tide over a separate financial crisis. Anyway, so with the funds that were provided by the corporate debtor, Energy Properties was able to purchase this particular parcel of land. The total sale consideration was 2.97 crore. Of that, you can already see that the corporate debtor had contributed 2.7 crores towards that. As a part of the arrangement that had been entered into between Energy Properties and the corporate debtor, Energy Properties had conveyed exclusive development rights over the land to the corporate debtor. And also the corporate debtor was in the actual physical possession of the property. There were a number of agreements. There were 6 agreements recording all of these facts that were entered into between the corporate debtor, Energy Properties, and as we'll see, there were some third parties involved as well, right? In August 2011, the corporate debtor executed a leave and license agreement granting Victory Ironworks Limited a license to use 10,000 square feet out of the total 10.19 acres of the property. Right? If you read the whole judgment, you'll see that at some point of time, Victory Ironworks claims that it had a license to use the entire property, the whole 10.19 acres, at a price of, I think, just 5,000 rupees per month or 10,000 rupees per month, some very, very ridiculous amount. But that was the contention that was taken. Okay, so at some point, the corporate debtor was taken into insolvency. So CIRP was initiated. The IRP claimed that the development rights formed a part of the intangible assets of the corporate debtor, and therefore the same needs to be protected. It had a duty to protect it under Section 25, subsection 2, as well as 18, clause F. Energy Properties objected to this proposal. It said that I have title to the land. This is land which I own. Even though the corporate debtor may claim to be in possession of it, even though the corporate debtor may claim to have development rights over it, in effect, the title of the land belongs to me, Energy Properties. All right. Victory Iron also opposed it, saying that they are in possession of the entire parcel of land. And if you look at that explanation to Section 18, it specifically says that the NCLT does not have power to evict a tenant or a lessee or a licensee who is in possession of the property. At some point, Energy Properties also began to forcefully remove security guards from the property. And then the IRP eventually filed an application under Section 25 seeking directions. The NCLT directed both Energy Properties and Victory Iron not to obstruct the possession, but it also respected the 10,000 square foot land that was licensed out to Victory Iron, saying that they will be permitted to carry on their activities in respect of that land. So aggrieved by this decision of the NCLT, both Victory Iron and Energy Properties moved the NCLAT. There also they lost, and then they came to the Supreme Court, and that's the case that we are considering right now. Right? So what did Victory Iron say in the court? Victory Iron said that under Section 25, subsection 2, clause A, the resolution professional is entitled to take custody and control only of the assets of the corporate debtor and not the assets of a third party. And what they're saying is that this land is essentially owned by Energy Properties, so it is not within the powers of the resolution professional to take control and custody of the land on the basis that the development rights in respect to that land belong to the corporate debtor. That's the contention that Victory Iron. And then it relies on the judgment of the Supreme Court in Embassy Property Development, where it was held that the adjudicating authority did not have jurisdiction to enter into this arena. This arena being essentially evicting a licensee in respect of land. Then we come to the arguments taken by the resolution professional, who in turn relies on another Supreme Court judgment, of Sushil Kumar Agarwal, which clearly says that the right of development of a property is an intangible asset of the developer, and it is especially so when the development project is shown in the balance sheet of the corporate debtor year after year. So the corporate debtor was showing that the project in question is that it has development rights in respect of it, and it was constantly being reflected in the balance sheet of the corporate debtor as well. So it's a very simple question came up for consideration before the Supreme Court, which is whether the development rights in respect of the parcel of land is an asset for the purposes of Section 25, subsection 2A and Section 18, clause F. And this is the question which the Supreme Court deliberated on and ultimately delivered a judgment on. And this is what the Supreme Court says. It is more clear than a crystal that a bundle of rights and interests were created in favor of the corporate debtor over the immovable property in question. The creation of these bundle of rights and interests was actually for a valid consideration, but for the payment of such consideration. So what they're talking about is this 2.7 crores which the corporate debtor gave to Energy Properties in order to buy the land in the first place. But for the payment of such consideration, Energy Properties would not even have become the owner of the property in dispute. Therefore, the development rights created in favor of the corporate debtor constitute property within the meaning of the expression under Section 3, subsection 27 of the IBC. Since the expression asset in common parlance denotes property of any kind, the bundle of rights that the corporate debtor has over the property in question would constitute asset within the meaning of Section 18, subsection 1, clause F, and Section 25, subsection 2, clause A. Now reading from paragraph 42 of the judgment. As rightly pointed out by learned counsel for the resolution professional, the explanation under Section 18 begins with a caveat, namely, for the purposes of this section. Therefore, the exclusion of assets owned by a third party, but in the possession of the corporate debtor, held under contractual arrangements from the definition of the expression assets is limited to Section 18. In other words, the explanation under Section 18 does not extend to Section 25. Right? So on this basis, the Supreme Court ultimately held that the intangible right, that is the development rights in respect of the property, is an asset and should be taken into account for the purposes of being included in the information memorandum, etc. Right? So this appeal was also ultimately dismissed. The appellant, which is Victory Ironworks, lost on both counts, and it was held that the development rights are liable to be included in the IM, and the RP is duty bound to take custody and control of the same. So that brings us to the fourth case. M.K. Rajagopalan versus Dr. Periyasamy Palani Gounder. And this was a fairly huge judgment compared to the other ones that we've gone through so far. There were several issues involved in this. It's not possible to go through all of the issues. I have extracted what I consider to be the 2 or 3 main issues in this judgment, and we'll cover the facts and the arguments that are relevant for these particular issues. This judgment was delivered in May 2023, authored by Justice Dinesh Maheshwari. The corporate debtor was Appu Hotels Limited, and the CIRP was initiated in respect of this company on the 5th of May 2020. At some point during the CIRP, resolution plan was submitted, and that resolution plan was approved by a fairly large majority, 87.39% voting share, in January 2021. However, the COC recommended certain changes to the resolution plan. Now, after these changes were incorporated, an application was moved before the NCLT seeking approval of the resolution plan. During the proceedings before the NCLT, several objections were raised by various financial creditors as well as by some of the promoters. The promoters, in the meantime, were trying to get a settlement and come out of the CIRP process. Presumably, they were pursuing a remedy under Section 12A of the IBC. All of these objections were rejected in the NCLT's order of 15 July 2021. This decision of the NCLT was appealed before the NCLAT. And some of the objections that were taken before the NCLAT were upheld. The RP was then directed to proceed with the CIRP from the stage of publication of Form G. Right? Now, there are some important facts in this case which we're going to cover. One of the observations that was made by the NCLAT was that the resolution applicant was ineligible in terms of Section 88 of the Indian Trusts Act and Section 164, subsection 2, Clause B of the Companies Act. Right? We'll look at how this came into play a little more closely. The resolution applicant, that is Mr. Rajagopalan, was the director of International Aviation Academy Private Limited. The audited financials of this company showed that between 2010, 2011 to 2017-18, a sum of approximately 12 lakhs was collected as share application money pending allotment, and this money was never refunded. Therefore, it was said that this money would constitute a deposit under the Companies Act and the deposit rules, and consequently, on account of, by virtue of Section 164, subsection 2B, Mr. Rajagopalan stood disqualified from acting as a director for a period of 5 years. It also happened that the resolution applicant was the founder and managing trustee of Sri Balaji Vidyapeeth, which was a charitable trust, right? A non-profit sort of charitable trust. And this trust had also submitted an expression of interest. But on account of the fact primarily that it was a charitable trust, it could not carry on a business for a profit, it was declared to be ineligible to submit a resolution plan. So you had a situation where the trust in respect of which Mr. Rajagopalan was the founder and managing trustee wanted to be a resolution applicant and submitted an expression of interest. And also Mr. Rajagopalan in his individual capacity also submitted an expression of interest and subsequently a resolution applicant. So you had essentially, I mean, you could argue that you had two plans being submitted effectively by the same person. Okay. And not to put too fine a point on what I said, but when Mr. Rajagopalan submitted his own resolution plan, he relied on the financial credentials of this Sri Balaji Vidyapeeth Trust, which was a charitable trust. Right? So these were the facts. As I said, there are several other facts in this particular case. I am only looking at the material facts that are relevant for the purposes of the three issues which I have culled out. So now let's come to the contentions that were made before the court. And I've pulled out the contentions for each of the issues. So the first is on the question of disqualification under 164(2) of the Companies Act. The resolution applicant would submit that the appellant, that is the resolution applicant, could not be held ineligible under Section 29A, Clause E of the Code. And this is the disqualification which says that if you are disqualified from being a director of a company, then you are ineligible to submit a resolution plan. That's what Section 29A, Clause E says. So the appellant could not be held ineligible under Section 29A, E of the Code, as the Registrar of Companies had not disqualified him under Section 164, subsection 2, Clause B of the Companies Act for the alleged non-refunded deposit in this other company, International Aviation. Furthermore, the DIN status of the appellant was active compliant, and the NCLAT did not consider its own judgment of C. Raja John versus R. Raghavendra. Right? In that judgment, it was held that if the DIN is activated, then 29E of the code will not be applicable. To counter this, the argument that was taken by the respondent was that because of this share application money pending allotment, which had not been refunded, it would result in the same being treated as an unrefunded deposit within the meaning of the proviso to explanation A of Rule 21C 8, Roman numeral 8 of the deposit rules, and result in disqualification of the appellant from being a director under 164(2)(b, and consequently from being a resolution applicant in the CIRP in question. The point which the respondent was trying to make was that as soon as you have committed a non-compliance as far as unrefunded deposit is concerned, you stand disqualified from being a director from, automatically from that moment itself. You do not require a formal order from the ROC or to tell you that you are disqualified to be a director. Then let's look at the second question, the second issue, which was on the point of the fact that there was one expression of interest that came from the trust and one from Mr. Rajagopalan in his individual capacity. And this gentleman is also the founder and managing trustee of the trust. It has been submitted by learned senior counsel that Section 88 of the Trusts Act would not be treated as a ground for disqualification of the appellant under Section 29A of the Code. Although the trust in question was held to be ineligible at the stage of EOI, the appellant was still held to be eligible in his individual capacity. So Section 88, I'll just tell you in very broad terms, it says that if you're a trustee of a trust, then you should not be competing with that trust, and any financial advantage that you gain needs to be made over to the trust. And so this sort of comes in the way of both the trust and a trustee being resolution applicants in respect of the same corporate debtor. So now we see the argument that is made by the respondent. The main plank of submissions with respect to violation of Section 88 is that there is a conflict of interest as the appellant is competing in his capacity as an individual with interests of a trust in which he was the founding managing trustee. In the face of these facts, the appellant simultaneously submitting a resolution plan in his individual capacity by taking support from financial credentials of the same trust basically sought to achieve indirectly what he could not directly. On the third issue, and this issue is a fairly significant issue as well. The issue was that after the resolution plan had been approved by more than 87% of the COC had suggested that some changes were required to be made. Those changes were incorporated. And then the resolution plan was directly submitted for approval by the NCLT. And the question was, before it went to the NCLT, should the COC have blessed the plan a second time? Essentially, should a vote of the COC have been taken before it was put for approval to the adjudicating authority? Right. What is the contention that was taken? The resolution applicant was only required to provide for redistribution to ensure that the dissenting financial creditors were given their share in terms of Section 30, subsection 2, clause B of the code. So you'll know that that particular provision says that provision should be made for distributions to the dissenting financial creditors, and it tells you how you should make that provision and what their entitlement is. So after the resolution plan was initially approved by this 87.39%, the applicant is making the case that resolution applicant is making the case that, look, all I had to do was to comply with that particular provision, and it was a fait accompli. It was definitely going to be approved by the COC. And although there was no formal vote of the COC that was taken on it, the fact that they did not subsequently raise any objection should be construed as if the COC has blessed. Right? You can see this particular line over here as well. The revised plan was then placed before the COC in the 10th COC meeting, and no objections were raised at that time. So by contrast, what does the respondent say? What does the respondent say? The respondent says that coming to the issue of non-placing of the final resolution plan before the COC, with reference to the minutes of the 9th COC meeting, when the resolution plan was put to vote, there was a requirement for the resolution professional to send the plan back to the resolution applicant to comply with section 30 subsection 2 IBC. However, after this, the revised plan was directly placed before the NCLT and not before the COC, which stands in violation of sections 30 subsection 2, 30 subsection 4, 30 subsection 6, and 31 of the IBC. So let's look at what the Supreme Court says on all of these points. Okay. On the point of 164 subsection 2B of the Companies Act, the Supreme Court said that unless a categorical finding was recorded in the competent forum as regards any such default, and unless specific order disqualifying the resolution applicant as director because of such default came into existence, it could not have been taken by way of any process of assumption that the appellant resolution applicant was disqualified to act as a director. So in other words, it says that if you are saying that the director is disqualified under 164(2)B, there needs to be a formal order of the competent authority that such and such person is disqualified to act as a director. It cannot be something that is assumed. It is not something that operates automatically. That's the view that the Supreme Court has taken. Then we come to the point on the trust also being a potential or a prospective resolution applicant. Here it says that the appellate tribunal has rightly held that the applicant, Mr. M.K. Rajagopalan, being the managing trustee of the said trust, cannot be permitted to act as its alter ego in implementing the resolution plan to gain financial advantage for himself. Then it also looks at section 166 subsection 4. This is a point I did not mention in the facts, but it so happens that this resolution applicant, Mr. Rajagopalan, also was involved as managing director of a company called MGM Healthcare Private Limited. Okay, so what the Supreme Court says is that given the status of the resolution applicant as managing director of MGM Healthcare Private Limited, his dealing with property of the corporate debtor and converting the same into a hospital cannot be said to be having no impact on the activities of the said MGM Healthcare Private Limited. So you may recall from your reading of the Companies Act, section 166 is the duties of directors. And there is a prohibition on doing things which will bring you in conflict with your role as a director of a company. So what the Supreme Court is essentially saying is that, look, if we allow you to go ahead and become the resolution applicant and approve your resolution plan, and you then do what you say you're planning to do with the property of the corporate debtor, then that will essentially put you in conflict with your role as managing director of this other company, MGM Healthcare Private Limited. And if you are going to if you're going to create a conflict as far as that company is concerned, you are in violation of section 166 subsection 4 of the Companies Act. And we know that section 30 subsection 2 clause E of the IBC says that a resolution plan must not result in a contravention of law. So to that extent, that was another reason that was found to disprove or disapprove of the resolution applicant going ahead with this resolution plan. And then on the point of whether the revised resolution plan had to be placed before the COC for a subsequent approval as well. See what the Supreme Court says. However, on a close look at the scheme of the IBC, this irregularity of not placing the revised plan after 9th meeting before the COC and directly placing it before adjudicating authority cannot be ignored as a mere technicality. As noticed herein above, each and every aspect relating to the resolution plan, and more particularly its financial layout, has to be considered by the COC before it could be said to have arrived at a considered decision. Looking to the nature and form of decision taken by the COC in the 9th meeting, such a conditional approval could not have been treated as a final approval. Whereafter, whatever be the revision, the plan was only to be presented to COC and could not have been presented to the adjudicating authority. I'm sorry, and could have been presented to the adjudicating authority only after final approval of COC by the requisite majority. So it's very clear on this point as well. So in conclusion, what happened is that the Supreme Court affirmed some portions of the NCLAT judgment. It set aside some other findings and observations. It also held that the adjudicating authority was at liberty to consider fresh settlement proposal that was submitted by the promoter in accordance with law, as well as the observations that were made in this judgment. Okay, so I think now that brings us to we're halfway through. We finished 4 judgments. We have 4 more judgments to go. Atul, would you suggest that I continue with these 4 judgments, or do you want to pause for some questions on these and then
I think let us finish the judgments, then we can take up the question and answer session in last.
Sure, no problem.
Yeah.
No problem. I think these next 4 judgments will hopefully also finish off a little more quickly. This judgment, which I'm going to talk about next, is something which I'm sure a lot of you will be familiar with. Vidarbha Industries Power Limited versus Axis Bank Limited. It was a 2022 judgment, came out in July 2022, and it created a lot of furor. As we'll see in this, the judgment was subsequently put up for review before the Supreme Court. That review was rejected. There were some observations that were noted in that review, and there have been subsequent judgments as well. There have also been subsequent developments about potential amendments to the IBC. So we'll look at some of these things as well. This was a judgment that was authored by Justice Indra Banerjee. Right. So Vidarbha Industries was a generating company under the Electricity Act. It had set up a 600 megawatt coal-fired thermal plant in Nagpur. The Maharashtra Electricity Regulatory Commission had granted approval to RIL to procure power from Vidarbha Industries unit. So a power purchase agreement was entered into. The MERC also approved the tariff for the power plant for financial years 2014-15 and 15-16. In 2016, Vidarbha Industries moved an application before the MERC seeking a truing up of the aggregate revenue requirement on account of increased fuel costs and the rise in cost of procuring coal. So essentially, what this would have done is it would have resulted in a higher tariff, and that would have resulted in more revenue being generated for Vidarbha Industries. But the MERC disposed of this application, effectively disallowing the substantial portion of actual fuel costs and cost increases that were claimed by Vidarbha Industries. But Vidarbha Industries challenged this before the APTEL, that's the Appellate Tribunal for Electricity Disputes. And the APTEL decided the case in favor of Vidarbha Industries, and a sum of approximately 1,730 crores became due to Vidarbha Industries. So this is the amount which should have been paid to VIPL, but MERC challenged the decision of APTEL in the Supreme Court. So there's a statutory mechanism, the same way we have in Section 62 in the IBC. There's a statutory mechanism to challenge decisions of the Appellate Tribunal for Electricity Disputes also before the Supreme Court, and that's exactly what happened. That case was pending in the Supreme Court. In the meanwhile, Axis Bank filed an application to initiate CIRP under Section 7. It was a financial creditor. The debt due from Vidarbha Industries to Axis was 533 crores, and the total debt owed to the consortium was in the amount of 2,700 crores, so a massive amount. VIPL moved an application in the NCLT seeking a stay on the proceedings, saying that, look, this appeal of MERC is pending in the Supreme Court. Let that be decided, then you go ahead with with the Section 7 proceeding, if there is a requirement for that proceeding to be continued. All right. This contention was rejected by VIPL, or this application was dismissed. VIPL then went to the NCLAT, that was dismissed, and then they came before the Supreme Court. Let's look at the contentions that were taken. A bare perusal of the aforesaid provision shows that the word used in Section 7, subsection 5, clause A, IBC is may, which must be interpreted to say that it is not mandatory for NCLT to admit an application in each and every case where there is an existence of a debt. The discretion conferred by 7.5a enables NCLT to reject an application even if there is existence of debt for any reason that NCLT may deem fit. Mr. Gupta argued that if the legislature had intended that an application must be admitted upon existence of a debt, then the terminology used in Section 7, subsection 5, clause A, IBC would have been shall and not may. In response, Axis Bank said that Section 7, subsection 5, clause A, IBC cast a mandatory obligation on the adjudicating authority to admit an application of the financial creditor under Section 7, subsection 2. Once it was found that a corporate debtor had committed default in repayment of its dues to the financial creditor. And it pointed to various decisions, including Innoventive, saying that once there was a debt and there was a default, the adjudicating authority was duty-bound to admit the corporate debtor to insolvency. But let's look at what the Supreme Court judgment says. Ordinarily, the word may is directory. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. If Section 7, subsection 5, clause A, IBC is construed literally, the provision must be held to confer a discretion on the adjudicating authority. The fact that the legislature used may in Section 7, subsection 5, clause A, IBC, but a different word, that is shall, in the otherwise almost identical provision of Section 9, subsection 5, clause A, shows that may and shall in the two provisions are intended to convey a different meaning. It is apparent that the legislature intended Section 9, subsection 5, clause A, IBC to be mandatory and Section 7, subsection 5, clause A, IBC to be discretionary. Even though Section 7.5a may confer discretionary power on the adjudicating authority, such discretionary power cannot be exercised arbitrarily or capriciously. If the facts and circumstances warrant exercise of discretion in a particular manner, discretion would have to be exercised in that manner. And then it gives an example. So it says the adjudicating authority has to consider the grounds made out by the corporate debtor against admission on its own merits. For example, when admission is opposed on the ground of existence of an award or a decree in favor of the corporate debtor, and the awarded decretal amounts exceed the amount of the debt, the adjudicating authority would have to exercise its discretion under 7.5a IBC to keep the admission of the application of the financial creditor in abeyance, unless there is good reason not to do so. So this was the position. So Vidarbha Industries succeeded in this appeal. The orders of the NCLT and NCLAT were set aside. As I mentioned to you at the beginning of this particular case, a review petition was referred a few months after the judgment had come out. It said that there was another judgment of the Supreme Court which was not taken into account, which was overlooked, which was E.S. Krishnamurthy versus Bharat High-Tech Builders. The review petition was dismissed on the basis that this particular case, E.S. Krishnamurthy, did not look at the question of whether Section 7, subsection 5 was mandatory or not. The question over there was whether the NCLT could foist a settlement on unwilling parties. So the question which had been considered in Vidarbha Industries was not a question that was considered in E.S. Krishnamurthy. So for that reason, that judgment was not relevant to the Supreme Court. So it could not be said that it had been overlooked. All right. Then, as I mentioned to you, in January 2023, the MCA had come out with a proposal of various amendments to the IBC, including making it mandatory for the NCLT to admit Section 7 petitions if debt and default were established. But as far as I'm aware, these amendments have not yet been given effect to. I'm not sure why. And related to the Vidarbha judgment is this case of 2023, M. Suresh Kumar Reddy versus Canara Bank and others. Right. This was a judgment of 11 May 2023. Judgment was authored by Justice Abhay Oka. So the corporate debtor was one Kranti Edifice Private Limited, which was admitted to CIRP by way of an order of the NCLT Telangana in June 2022. It had availed of certain credit facilities from Syndicate Bank. Syndicate Bank then merged with Canara Bank. So it was actually Canara Bank that filed the Section 7 petition to initiate CIRP. As I mentioned to you, Syndicate Bank had previously sanctioned credit facilities to the corporate debtor, and including a secured overdraft facility of 12 crores and a bank guarantee limit of 110 crores. In the Section 7 application, Canara Bank claimed that the corporate debtor's liability under the overdraft facility was approximately 74.5 crores, and towards the outstanding bank guarantees was approximately 19.16 crores. And by way of background, the government of Telangana had awarded various contracts and projects to the corporate debtor. And on various occasions, representatives of the government of Telangana, there were some engineering contracts. So you had the executive engineer of one of the departments write to the bank requesting that the bank guarantees be extended. And the corporate debtor had also addressed similar letters requesting extension of the bank guarantees, but none of these requests were acceded to. So the financial creditor did not heed any of these requests and pursued its Section 7 application. And ultimately, the NCLT put the company into CIRP. Now, the appellant over here is a suspended director of that corporate debtor. He was aggrieved by the decision of the NCLT. He moved the NCLAT in appeal. The NCLAT also rejected his appeal, and so he then came to the Supreme Court. So let's look at the contentions that were made. Learned senior counsel appearing for the appellant submitted that repeated efforts were made to have a one-time settlement of the dues payable to the first respondent, but the said request was not acceded to. Then he relies on the Vidarbha Industries judgment. He says that even assuming that the existence of financial debt and default on the part of the corporate debtor was established, the NCLT was not under an obligation to admit the application under Section 7. And for good reason, the NCLT could have refused to admit the application under Section 7. And what was the good reason over here? The good reason that was asserted was that, look, you have the government who has awarded projects to me, and the government itself is asking you, the bank, to extend the bank guarantees. So the fact that you have rejected it despite the government having granted me contracts and having made requests itself is something that you should not have done. As in, you should not have rejected those requests. You should have acceded to those requests. That's the position that was taken by the appellant. In response, Canara Bank said that the decision in the case of Vidarbha Industries is in the peculiar facts of that case, as is explained by the bench while disposing of the review petition. And then he points to that E.S. Krishnamurthy judgment itself as well. And then they say that he therefore submitted that once NCLT is satisfied that there is a financial debt and a default has occurred, it is bound to admit an application under Section 7. This is the position that we just saw in the case of Vidarbha itself. It's the same argument that was made by the financial creditor in that case. So now coming to the judgment, even the non-payment of a part of debt when it becomes due and payable will amount to default on the part of the corporate debtor. In such a case, an order of admission under Section 7 of the IBC must follow. If the NCLT finds that there is a debt, but it has not become due and payable, the application under Section 7 can be rejected. Otherwise, and this is the important bit, there is no ground available to reject the application. This is the same position that was there in the case of Innoventive as well. Moving on. Thus, it was clarified by the order in review that the decision in the case of Vidarbha Industries was in the setting of facts of the case before this court. So all of these judgments are now trying to essentially say that Vidarbha was laying down the law only in respect of the specific facts of that case. It did not lay down a general rule as such. That seems to be the position being taken by these judgments. Hence, the decision in the case of Vidarbha Industries cannot be read and understood as taking a view which is contrary to the view taken in the cases of Innoventive and E.S. Krishnamurthy. The view taken in the case of Innoventive Industries still holds good. Then another interesting point, which was noticed by the Supreme Court, and they say that in this case, we must note that the amount payable by the corporate debtor also included the amount repayable under the fund-based credit facility of secured overdrafts. And this is relevant because there were two kinds of facilities that were extended by the bank. One was a secured overdraft facility and the other was a bank guarantee limit. And if you recall, the government of Telangana was only telling the bank to keep extending its bank guarantees. It wasn't saying anything about the secured overdraft facility. So this discrepancy was unearthed by the Supreme Court, and it said that the facility granted to the corporate debtor was not confined to bank guarantees alone. Right? So that was the judgment of Suresh Kumar Reddy versus Canara Bank and others. This appeal was ultimately dismissed, and the decisions of the NCLT and the NCLAT were affirmed. That brings us to the end of the sixth judgment. And we'll now begin another judgment, which I'm sure a lot of you are very familiar with and have come across. And this is the case of State Tax Officer versus Rainbow Papers Limited. This judgment came out in September 2022, which was incidentally just around the same time as when the review petition in Vidarbha Industries was also rejected or dismissed. And it's interesting to note that the same judge who authored the judgment of Vidarbha Industries also authored the judgment in Rainbow Papers. So let's look at this judgment as well. Let's take a quick. So the corporate debtor, Rainbow Papers Limited, was engaged in the business of manufacture and sale of crafts and ores within and without the state of Gujarat. The Gujarat State Tax Department assessed Gujarat VAT and central sales tax, and the amount was in the range of approximately 53.71 crores. The State Tax Department had initiated recovery proceedings in July 2016, and in October 2018, the property of the corporate debtor was also attached. Okay. And it's interesting to note that this property of the corporate debtor was attached after the CIRP had actually been initiated in respect of Rainbow Papers. As you will see in the next point, an operational creditor of the corporate debtor, Neeraj Papers Private Limited, filed a Section 9 application to initiate CIRP, which came to be admitted in September 2017. The resolution professional invited claims from creditors, received a number of claims. One of the claims which came, albeit belatedly, was from the state tax officer. from the Gujarat State Taxes Department. They filed a claim in Form B, claiming approximately 47.36 crores. A resolution plan had been submitted in respect of the corporate debtor. The resolution applicant was Kushal Limited. In the meanwhile, the State Tax Department was following up on its claim. It had sent a number of communications to the RP asking what had happened to the claim. And in response to these communications and requests, the RP informed the State Taxes Department that its entire claim had been waived off, right? Wiped out. On 20th December 2018, the State Tax Officer challenged the resolution plan in the NCLT, asserting that it was a secured creditor and should be treated as such in the resolution plan. Section 48 of the Gujarat VAT Act provides that any amount payable by a dealer on account of tax, interest, or penalty for which he is liable to pay the government shall be a first charge on the property of the dealer. This is a very important provision, and this became, I think, a provision on which the case eventually turned. So before the NCLT, the State Tax Officer's application was rejected. It was aggrieved by that decision, and it went to the NCLAT in appeal. The NCLAT also dismissed it, and then it came to the Supreme Court. What were the contentions that were taken? So the learned Solicitor General rightly argued that in view of the statutory charge in terms of Section 48 of the Gujarat VAT Act, the claim of the Tax Department of the state squarely falls within the definition of security interest under Section 3, subsection 31 of the IBC, and the state becomes a secured creditor under Section 3, subsection 30 of the Code. In other words, it was saying that if you just look at this first charge provision under Section 48, it was saying that on account of that statutory provision, I have a charge on the property, and therefore I need to be treated as a secured creditor. That, in substance, is the point that was made. Let's see further. The learned ASG argued that it was not the case of the appellant that Section 48 of the Gujarat VAT Act prevails over Section 53 of the IBC. It was the case of the appellant that the state falls within the purview of the secured creditor. Why is this relevant? It's relevant because there are non-obstante clauses both within the Gujarat VAT Act as well as the IBC. So the IBC, we know Section 238 is a non-obstante clause which gives primacy to the IBC over all other legislations. But the IBC is not the only law or the only code which has that kind of language. You have similar language in a number of other legislations. One of those legislations is the Gujarat VAT Act, which in this same section of Section 48, there was a notwithstanding anything containing any other law for the time being enforced, that language was there. And it was initially thought that the State Tax Department was asserting its claim on the basis that the Gujarat VAT Act trumped over the IBC. But one of the ASGs clarified to the Supreme Court that no, that's not the point that we're making at all. We're only saying that on account of Section 48, we become a secured creditor. We're not saying that there's a conflict between the Gujarat VAT Act and the IBC. Let's see further. The learned ASG submitted that the mere fact that a creditor might be an operational creditor would not result in loss of status of that operational creditor as a secured creditor. In other words, it would be possible for a creditor to be an operational creditor whilst being a secured creditor. So you could be a secured operational creditor. All right. Coming to the judgment. The Supreme Court says that under Section 31 of the IBC, a resolution plan is approved by the COC under subsection 4 of Section 30 might be approved by the adjudicating authority only if the adjudicating authority is satisfied that the resolution plan as approved by the COC meets the requirements as referred to in subsection 2 of Section 30 of the IBC. The condition precedent for approval of a resolution plan is that the resolution plan should meet the requirements of subsection 2 of Section 30 of the IBC. if the resolution plan ignores the statutory demands payable to any state government or a legal authority, the adjudicating authority is bound to reject the resolution plan. In our considered view, the committee of creditors, which might include financial institutions and other financial creditors, cannot secure their own dues at the cost of statutory dues owed to any government or governmental authority, or for that matter, any other dues. So what the Supreme Court is saying is that, look, you financial creditors, you cannot secure your dues at the cost of crown debts or government debts or statutory debts. All right. Those debts, to the extent that they are statutorily empowered with a first charge provision, should also be regarded as a secured debt. Section 48 of the GVAT Act is not contrary to or inconsistent with Section 53 or any other provision of the IBC. Under Section 53, subsection 1, clause B, subclause Roman numeral 2, the debts owed to a secured creditor, which would include the state under the Gujarat VAT Act, are to rank equally with other specified debts, including debts on account of workmen's dues for a period of 24 months preceding the liquidation commencement. Right? If you remember that waterfall under Section 53, subsection 1, it's saying that these dues, these statutory dues under Section 48 of the Gujarat VAT Act is elevated to the level of, or elevated to the status of a secured debt, or a debt owed to a secured creditor, and should be, it therefore falls in that portion of the waterfall. As observed above, the state is a secured creditor under the Gujarat VAT Act. Section 3, subsection 30 of the IBC defines secured creditor to mean a creditor in favor of whom security interest is credited. Such, I think it should be created. Such security interest could be created by operation of law. The definition of secured creditor in the IBC does not exclude any government or governmental authority. All right. So on that basis, the dues owed to the Gujarat State Taxes Department was elevated to the status of a secured, or a debt owed to a secured creditor, and was then required to be treated as such. So here's what happened because of this judgment. The appeal of the state tax officer was allowed. The orders passed by the NCIT NCLAT was set aside. The resolution plan was also set aside. The resolution professional was given liberty to consider a fresh resolution plan in light of the observations made in this case. And this case basically says that statutory dues that are empowered with a first charge statutory provision, like we saw in Section 48, should be treated as secured debts. And further, the court also said that the resolution applicant is at liberty to submit a fresh resolution plan in light of the observations made in this case and making provision for the dues of statutory creditors. So it's crystal clear about what the resolution applicant needs to do if they want to participate in a subsequent resolution plan. They want to submit a subsequent resolution plan. All right. So that then brings me to the last judgment, which I will be discussing today. And then we can have a question answer session, which is Paschim Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited and others. And the question in this case was whether government debts can be treated as debts owed to a secured creditor in light of the specific enumeration under 53 subsection 1 clause E of the IBC. Just moments ago, I told you that in Rainbow Papers, the Supreme Court said that statutory dues could be regarded as being secured debts for the purpose of the waterfall. But this question has come up again in another case. The judgment was delivered on 17 July 2023. It was authored by Justice Ravindra Bhatt, again, whose judgments I thoroughly enjoy reading and I learn a lot from. So let's go through the facts. So PVVNL and the corporate debtor, that is Raman Ispat Private Limited, enter into an agreement for the supply of electricity. Clause 5 of the electricity supply agreement provided that outstanding dues will be a charge on the assets of the company. You also had a provision under the UP Electricity Supply Code of 2005. So clause 4.3 of the 2005 code provided that outstanding dues will be a first charge on the assets of the company. So here again, you have a similar construct to what you had in Rainbow Papers, in the sense that you have statutory provisions, or in this case, delegated legislation, providing that outstanding dues will be a first charge on the assets of the company, right? In January 2016, PVVNL attached the corporate debtors' properties since electricity dues remain unpaid. Then on the 23rd of January 2016, the Tehsildar of Muzaffarnagar restrained the transfer of property by sale, donation, or any other mode, and also created a charge on the properties. All of this was happening, I believe, when the CIRP was already in place. And this becomes relevant because it helps you understand why the liquidator eventually then had to go to the courts and say that, look, if these attachment orders remain, if these orders restraining transfers remain, then it will be impossible for us to sell the properties and ultimately liquidate the corporate debtor. So as on 27 January 2017, the total arrears due to PVVNL from the corporate debtor was approximately 4.32 crores. And the district collector issued notice for recovery of dues of approximately 2.5 crores by auction of properties. As I just said, the liquidator moved the NCLT and said that these attachment orders of the district collector need to be set aside because these orders will come in the way of buyers purchasing the properties of the corporate debtor under the aegis of the IBC. The liquidator also took the position that PVVNL's claim would be classified in order of priority described in section 53 of the IBC. Accordingly, PVVNL would be entitled to pro rata distribution of proceeds along with other secured creditors from the sale of liquidation assets. The NCLT approved the liquidator's application seeking immediate release of the corporate debtor's properties. PVVNL was aggrieved with this order of the NCLT. It went to the NCLAT, lost in the NCLAT, and then came to the Supreme Court. So in the Supreme Court, what arguments were taken? So being a special law relating to all aspects of electricity, so it's talking about the Electricity Act of 2003. Being a special law relating to all aspects of electricity, generation, transmission, distribution, and adjudication of disputes, it had primacy over all other laws, including the IBC, which was a general law dealing with corporate insolvency implemented much later. In terms of the 2003 Act and the regulations framed under it, including the UP Electricity Supply Code of 2005, a special mechanism for recovery of electricity dues existed. The rights of electricity suppliers like PVVNL, therefore, were not subordinate and subject to the priority of claims mechanism under the IBC. They're talking about the waterfall over there. Therefore, PVVNL could opt to independently stay out of the liquidation process and recover its dues. Learned Counsel also relied upon the decision of this court in Rainbow Papers, in which this court held that by virtue of a security interest created in favor of the government for tax claims under the Gujarat VAT Act of 2003, tax authorities, i.e. the government, was a secured creditor under the IBC. In response, what does the liquidator say? The liquidator says, government dues were placed in the waterfall mechanism under section 53, subsection 1, clause E, Roman numeral I of the IBC. Learned Counsel emphasized that even under the Old Companies Act of 1956, Section 529A provided priority to the debts due to the secured creditors and the workers, and Section 530 made payment of taxes subject to the priority embedded in Section 529A. You can ignore that part about the Old Companies Act. Essentially, the liquidator is taking the position that these dues of PVVNL, which is a state body, should be treated as a government debt, as a debt owed to the central government or state government. If you look at section 53, subsection 1, clause E, you can see that language. It's saying that that is how it should be treated. It should not be treated as a security. Let's read further. Learned Counsel submitted that electricity dues did not enjoy any priority. It was submitted that creation of charge under a law was a matter of fact which had to be proved. In the present case, the statute merely enabled recovery of electricity dues as though they were recovery of arrears of revenue. This did not result in the creation of security interest in favor of the appellant. And now let's look at this judgment. I think it's a wonderful judgment in a lot of ways. This court held that the creation of a charge need not necessarily be based on an express provision of the 2003 Act or plenary legislation, but could be created by properly framed regulations authorized under the parent statute. In these circumstances, the argument of PVVNL that by virtue of clause 4.3 F, Roman numeral 4 of the supply code, read with the stipulations in the agreement between the parties, a charge was created on the assets of the corporate debtor is merited. So the court has accepted that aspect of it. And it says that this is evident from the order of the NCLAT, which clarified that PVVNL also came under the definition of secured operational creditor as per law. So, as you can see, the Supreme Court has read clause 4.3 subclause F, Roman numeral 4 of the supply code to say that a charge exists in respect of the properties. A charge has been created in respect of the properties, and therefore PVVNL is a secured creditor. So to that extent, it's fine. Now let's read further. The specific mention of other class of creditors whose dues are statutory, such as dues payable to workmen or employees, the Provident Fund, Pension Fund, the Gratuity Fund under Section 36, subsection 4, which excludes these enumerated amounts from the liquidation, especially clarifies that not all dues owed under statute are treated as government dues. In other words, dues payable to statutory corporations which do not fall within the description amounts due to the central or state government, such as, for instance, amounts payable to corporations created by statutes which have distinct juristic entity, and one of them would be, for example, PVVNL, but whose dues do not constitute government dues payable or those payable into the respective consolidated funds stand on a different footing. On the other hand, dues payable or requiring to be credited to the treasury, such as tax, tariff, etc., which broadly fall within the ambit of Article 265 of the Constitution, are government dues. So things like taxes, etc., those would fall within the classification or the category of debts owed to the central government or the state government, and would therefore come under clause E of that waterfall, section 53, subsection 1, clause E of the waterfall. Now, the Supreme Court directly deals with the Rainbow Papers judgment. Rainbow Papers did not notice the waterfall mechanism under section 53. The provision had not been adverted to or extracted in the judgment. That's how we know that the waterfall mechanism was not noticed. Furthermore, Rainbow Papers was in the context of a resolution process and not during liquidation. The careful design of section 53 locates amounts payable to secured creditors and workmen at the second place after the costs and expenses of the liquidator payable during the liquidation proceedings. However, the dues payable to the government are placed much below those of secured creditors and even unsecured and operational creditors. This design was either not brought to the notice of the court in Rainbow Papers or was missing altogether. Let's read further and then I'll just come to the conclusion on this. the Gujarat VAT Act 2003 no doubt creates a charge in respective amounts due and payable or arrears. It would be possible to hold, now look at this part in parenthesis, it's very important. It would be possible to hold in the absence of a specific enumeration of government dues, as in the present case in section 53 subsection 1E, that the state is to be treated as a secured creditor. However, the separate and distinct treatment of amounts payable to secured creditors on the one hand and dues payable to the government on the other clearly signifies Parliament's intention to treat the latter differently, and in the present case, having lower priority. All right, so essentially what it's saying, without using as many words, is it's saying that in the Rainbow Papers judgment, the court was not made aware of section 53 subsection 1 clause E, and the fact that there was a separate category of a separate place in the waterfall for debts owed to the central government or the state government. And had the Supreme Court been made aware of that, then it would have treated the outstanding VAT dues as falling under that category, rather than saying that those dues constituted a secured debt. And even if it could be said independently that the outstanding dues on account of VAT is a secured debt, because of this provision, section 53 subsection 1 clause E, that provision would take primacy, and it would have to nevertheless be treated as a debt owed to the government and would therefore fall lower in the waterfall. Right? So that's what happened. PVVNL's appeal was ultimately dismissed, and the liquidator was directed to decide the claim of PVVNL in accordance with law. Let's remember over here that what PVVNL wanted to do was to remain completely outside of the IBC framework. It had already attached the properties. It wanted to go ahead and sell those properties with no consequence or with no regard to what happened to the IBC or the liquidation proceedings of the corporate debtor. But what the Supreme Court has said is that, look, you can't do that. You have to be subjected to the discipline of the IBC, and you will be treated fairly and accordingly. All right, so I think with that, I come to the end of the cases that I wanted to discuss. We can now take up any questions that
we have received some questions. Thanks for this wonderful session. This is very knowledgeable. So first question is, how do you think the judicial pronouncements helping in the successful implementation of law?
So I think I have two remarks I want to make. The first is that it is simply not possible for the legislature, that is Parliament or the state legislature, this is with respect to any law, it's simply not possible for the Parliament to legislate for everything or to stipulate for everything. There will invariably be some gaps, and those gaps need to be filled by the judicial framework. Okay, I'm using the term judicial framework a little loosely over here. I want to include the NCLT, the NCLAT as well. These are tribunals. But they need to sort of step in, apply their mind, and try and fill in areas where there are genuine gaps. There are some areas where, as I said, it's not possible to stipulate for everything. So there may be gaps, and as practitioners, as stakeholders, we all look to the judicial forums to fill in those gaps. So to that extent, I think the judicial pronouncements do become very important, and they are very relevant in informing the practice of professionals as well.
So I want to add in this, we can take example of check bouncing case under section 138 of the Negotiable Instrument Act. It is so many year old act. Still judgments are coming, and they are improving the section 138 also. So next question is, kindly explain the dismissal of review in case of Vidarbha Industries private judgment.
So as I mentioned, what happened let me just give you some background about that review. That review was filed essentially to bring to the notice of the court that there was this other judgment of E.S. Krishnamurthy which had not been considered by the court. In fact, I think the word used was that the Supreme Court had overlooked the judgment of E.S. Krishnamurthy. The Supreme Court was aware of the interventive judgment, but there was nothing said about E.S. Krishnamurthy in the Vidarbha judgment. So the review was filed to bring that into the knowledge of the court. I think that was the basis on which it was presented to the court. The court said that, look, the E.S. Krishnamurthy judgment did not deal with the question of the interpretation of Section 7, subsection 5, specifically on the question of whether it is mandatory or direct or discretionary in nature. There was no discussion in that E.S. Krishnamurthy judgment about how the word may in Section 7 should be construed. And so that was one basis on which it was distinguished. The second basis was in the review case, it was also said that the E.S. Krishnamurthy judgment was looking at a case where the NCLT was trying to force unwilling parties to enter into a settlement. And it commented on what needed to be done in that instance. It was not looking at a case similar to the one that was presented in Vidarbha. And just to sort of recap on the Vidarbha judgment, what happened is you had a corporate debtor which had won an appeal in the APTEL and was to receive 1,730 crores from the as a consequence of winning that appeal. Now, the MERC had appealed that judgment in the Supreme Court, and that Supreme Court and that case was pending before the Supreme Court. Now, whilst that case was pending, you had some financial creditors who initiated CIRP against Vidarbha Industries. So there was a case where Vidarbha Industries could have, had the Supreme Court decided the case, then it would have received the dues and it would have been in a position to repay its financial creditors. But because the case was still pending before the Supreme Court, it was not in a position to do so. And therefore, the case was made to the Supreme Court that, look, had it not been for the pendency of this case, I would not be in this position. And so I could have cleared my outstanding dues. Right. So the review petition said three things. One, E.S. Krishnamurthy did not specifically consider the question that we have considered about whether Section 7, subsection 5A is mandatory or discretionary. B, it dealt with a completely different question, which is not what we were concerned with. And C, the third thing that it dealt with was that it said that, look, the ruling that we have laid down will apply to the facts of this case. In respect of other cases, you have to apply the law as it's been laid down in a host of other judgments. Now, I'll tell you, I have also done a case in the NCLAT. In fact, I think earlier this year is when it ended. Ashwini Kumar Chandrakar versus Central Bank of India. And the facts of my case were the state government of Chhattisgarh had acquired a medical college and hospital from a Section 8 company. And under a statute, there was a legislation under which this acquisition was made. And the legislation provided for a host of things. It said that we'll appoint an officer to conduct evaluation. The evaluation will be conducted in such and such time. The state government will pay up to, I think, if I'm not mistaken, 2x of the valuation. And the amounts will be disbursed within such. Everything was provided for under statute. Ultimately, what happened is that there were some delays in this timeline, and Central Bank of India had moved the NCLT. But we were able to show the NCLAT that because we had this statute, we essentially had a sovereign guarantee of the state saying that these monies were to come, and if these monies came, then we would not be we would not be essentially a corporate debtor who was unable to pay its debts, and that was accepted. So I just wanted to clarify essentially what the review said and why it was dismissed.
So next question is with respect to the case law of Supreme Court, Mojobea Karmachari Union versus Union of India. Audience want to understand principle laid down with respect of workmen dues under Section 326 of the Companies Act and even in the event of liquidation.
So unfortunately,
you are not aware. No issue.
Judgment. But Atulji, if you are aware, maybe you can.
I am also not aware right now. So next question is with respect to the judgment of Suresh Kumar Reddy versus Canara Bank, that we have already covered. You have already covered. Question is old.
Right.
So another question is whether a judgment passed by any bench of the NCLAT shall be binding on all other benches of the NCLAT, or they can pass different judgment.
So I think in practice we see that different
Yes,
of the NCLAT
there are so many cases we have seen.
What I would say is that there's a general judicial discipline that needs to be followed, and what that means is that if there's a larger bench of the NCLAT, for example, some cases I think you have 3 judges or 5 judges sitting on it.
Yes,
Then
yes.
those decisions will naturally be binding on 2 judge benches of the NCLAT. But otherwise, there is no apart from a basic self-discipline, the doctrine of precedent, what we call stare decisis. Apart from that, there is no such binding effect as such on one, decisions of one bench of the NCLAT on other benches of the NCLAT.
Next question is, in the case of Rainbow, it is explained that the government have submitted their claims after due date. So should it be accepted under judicial plan mandatorily?
So this is under Rainbow Papers?
Yes, yes.
So I think what happened in Rainbow Papers, and we now have a number of judgments on this as well. It says that a lot of the timelines that are stipulated under the both under the Act as well as the regulations, they keep saying that these timelines are directory in nature. And I think the general principle that is being followed is that as long as it is not coming in the way of the
Judicial plan.
moving ahead, as long as things are not going to be appended or things are not going to be disturbed or dismantled, it's okay to accept it even if it comes beyond the timeline. That's the sense I get from reading all of these judgments and about these timelines being directory in nature.
Rita ji, you can take up the things.
Yes, yeah. So far, these questions only had come. Aditya sir, maybe the share screen can be stopped so that we can have you on the bigger screen. Yes. Yeah, all the questions Atulji had taken. So we come to the end of this session. Thank you, Aditya ji, for taking us through very important recent Supreme Court judgments, especially Vidarbha, and then that Paschimachal Vidyut, and in Rainbow also you covered. So these are all, as we know, the judgments really help us. It gives us a clarity in understanding the various aspects and provisions, to know the things. And it is very important for the professionals to really understand if this kind of session helps them, in dissecting the various aspects of the judgment. Thank you, Aditya sir, for taking us through this. And thank you, Atulji, for moderating the session and putting all the questions before Aditya ji. So we come to the end of this session. So on behalf of Committee on Insolvency and Bankruptcy Code of ICI, we thank both of you, Aditya sir and Atul sir. And we also thank all the members who have joined live at this very important webinar today on the recent judicial pronouncement. Thanks to all of you. Thank you once again to Aditya sir and Atul sir. Thank you.
Thank you so much for inviting me. It was my pleasure to be here. I do hope.
I think Gyan sir has joined. So members.
मैडम मैं दूसरे मीटिंग में ज्वाइन कर चुका हूँ, मैं आपसे बाद में बात करूंगा.
ठीक है. Okay, Gyan sir.
Yes, madam. Yes.
Yes.
Good afternoon.
Thank you so
much. Good afternoon, Gyan ji.
We were about
Namaskar, sir.
to
Namaskar,
conclude.
Aditya ji. Good afternoon.
Good afternoon, sir.
Sorry, I could not join at the start of the meeting. We had some other program. So, question answer session completed, madam?
Yes, sir. Yes. We just completed. I was just formally giving them, thanking them on behalf of the committee, sir. So it is so, we are delighted, sir, to have you. Please, sir, share your thoughts, sir, on this webinar.
So thank you, madam. Very respected speaker Aditya ji and moderator Atul ji, and of course all the participants. Good afternoon to one and all. Friends, we all know that CIBC is working very hard this year under very prompt action by Madam Rita, because this year we have organized one very wonderful program, that is Resolve 2023 in Singapore. And in last 2.5 months, we have witnessed that the entire focus was on this international event only. Now we are again back, and we have started monthly knowledge capsule, a sort of monthly e-newsletter for the members. We'll request all the participants to kindly give your write-ups for the same, whatever you can do, give for the same. And moreover, we require more and more speakers, more and more resource person. We are looking for some technical papers in coming time, some white papers to be given to IBBI. So now the time has come that since the law is, taking new shape, and all the stakeholders of IBC are looking for some new change. So we are here to take the lead in the direction that we could really be helpful to all the stakeholders. Today itself, I in person met to IBBI Chairman sir. He is expecting a lot from us. So to become a resource person, to handhold each other, to have the research papers, to release the white papers, all these things are really need of our. So really that we all come together, we all strengthen the working of the committee, and of course, if needed, we should sit together for betterment of the insolvency and bankruptcy law. Friends, these judicial pronouncements has been discussed from time to time by the committee is of utmost importance. We can witness that each and every minute issues with respect to the judgment are being discussed by the learned speakers, and we are ready to organize so many more programs in coming time. Lot of programs are being designed, and those are been well planned by Madam, and that will be on floor within a week. I'm sure that this learning session and this type of learning session will not only enrich our knowledge, but certainly make us very much able to take the new challenges in coming time. Friends, few things which as of now is very much talk of town that I would like to summarize quickly. Number one, avoidance transaction. The government, especially the regulators, are highly, looking on this issue, especially how the avoidance transactions could be well reported and could be settled in time. I don't know what could be the, procedure, because nowadays avoidance transactions are not being undertaken to the best of the spirit of the, especially to the stakeholders, especially to the COC. So this is one thing the government is eyeing very high. The second one, the timeliness of the entire insolvency process. That is about 650 days or so. However, the government, when it started the things, when the law came, that was something else. So this is the other issue on which the regulators are very serious. They want that the time laggard should be reduced, whether it might be at the COC level or resolution professional level or at the judiciary level. Though we understand well that because of the paucity of the judges in the judiciary, a lot of cases have been, on hold for a long time. But I am happy to share that nowadays the hearings are started well, smartly, and so many cases are being scheduled by the NCLT on priority basis. To strengthen the law, to strengthen ourselves, to equip the knowledge, to hone the skills, this is need of our, and I'm sure that these type of sessions will not only enrich our knowledge, but they will certainly practically strengthen us to take the IBC law on actual working mode, and we will deliver to all the stakeholders to the best of our abilities in coming time. By these words, I am thankful to the learned speaker Aditya ji, my good friend Atul ji, and of course all the participants for giving their precious time for this event. Please keep connected with the committee and do write us whatever you have in your mind to strengthen not only the committee but to the IBC code. So thank you, madam, for organizing such a wonderful program, and I hope such programs we will see in future coming time on a regular basis as we were doing earlier. Thank you.
Thanks indeed to you, sir. Thanks, Chairman, sir, for joining us and sharing with us your thoughts and your perspective, and also highlighting the important activities which the committee is undertaking, sir, under the guidance and leadership of yours this time. And you had also brought before all the members the very two important issues on avoidance transactions and the timeliness of the entire process. And finally, you had also requested all the members to participate in the initiatives of the activities, be it in the form of write-ups or in any which way. If they would wish, they can write to us. So they can write to our committee mail ID, which is cibc@icei.in. So thanks indeed to you, sir. And thanks to
Thank you, madam. Thank you.
Aditya, sir, and thanks to Atul, sir, once again. So we conclude the session today, sir.
Thank you, madam. Thank you, one and all.
Thank you.
Thanks
Thank
to
you.
all.
Thank you, sir. Thank you, ma'am.
Thank you, sir.